I'd like to call this meeting to order. Welcome to meeting number 114 of the House of Commons Standing Committee on Indigenous and Northern Affairs. I do want to begin by recognizing that we meet on the ancestral and unceded territory of the Algonquin and Anishinaabe peoples, and as always express gratitude that we're able to do the important work of this committee on lands that they've stewarded since time immemorial. And pursuant to the order of reference of Wednesday, June 5th, 2024, the committee commenced consideration of Bill C-61, an act respecting water, source water, drinking water, wastewater, and related infrastructure on First Nation lands. But before we begin, I would like to ask that all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, including and especially the interpreters. Only use the black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from all microphones at all times. When you're not using your earpiece, please place it face down on the sticker placed on the table for this purpose. And I want to thank you all for your cooperation. Today's meeting is taking place in a hybrid format. In accordance with the committee's routine motion concerning connection tests for witnesses, I'm informing the committee that all witnesses have completed the required connection tests in advance, I believe, and if there may be a couple that we will have to work through as well. Before we turn to our witnesses, I just want to address something that Dr. Pulowski brought up in the last meeting about some of the challenges that we're having with the sound from interpreters. It was brought up at the liaison committee earlier today, and I understand it is something that the House of Commons administration is going to be looking at in detail over the course of the summer. So hopefully we'll have some ways of remedying some of the challenges that we've experienced in the last few weeks at least, once we return in the fall. And at the end of the meeting, I'm going to leave a little bit of time for us to do some important business to pass the budget for this committee so that we can move ahead with what we need to properly do this study. But with that, I would like to turn it over to our witnesses that are here today. From the Department of Indigenous Services, we have Joanne Wilkinson, the Senior Assistant Deputy Minister, Regional Operations Sector, Paula Haddon-Jokil, who's the Assistant Deputy Minister, Regional Operations Sector, Nelson Barbosa, the Director General, Community Infrastructure, Rebecca Blake, the Acting Director, Legislation, Engagement and Regulations. And from the Department of Justice, we have Douglas Fairburn, Senior Counsel, Legal Services, Department of Crown Indigenous Relations and Northern Affairs, and Department of Indigenous Services, as well as Leong Tan, Legal Counsel, Legal Services, Department of Crown Indigenous Relations and Northern Affairs, and Department of Indigenous Services. So with that, there will be up to 5 minutes given for opening remarks, after which we will proceed to the rounds of questions. So with that, I want to welcome you all. And I think first we have Ms. Wilkinson to deliver a 5-minute introduction, and the floor is yours.
Thank you very much, Mr. Chair. I'd also like to acknowledge that we are having this meeting on the unceded and unsurrendered traditional territory of the Algonquin and Anishinaabe people. And thank you on behalf of my colleagues as well. Je suis avec vous aujourd'hui pour...
I'm here today to talk about Bill C-61, an act respecting water, source water, drinking water, wastewater and related infrastructure on First Nation lands. Thank you for providing my colleagues and me with the opportunity to provide you with some information on this proposed legislation. Everyone in Canada should have access to safe, clean and reliable drinking water.
Do not have legally enforceable safe drinking water protections similar to what is in place currently in provinces and territories. In 2013, the Safe Drinking Water for First Nations Act was created to enable the development of federal regulations to support First Nations access to clean, reliable drinking water and effective treatment of wastewater. However, First Nations shared several concerns with this act, including the lack of adequate, predictable, and sustainable funding, the lack of recognition of Aboriginal rights, the potential infringement of Aboriginal and treaty rights, the lack of protection of source water, and insufficient engagement on issues that directly affect First Nations. As part of the 2021 Safe Drinking Water for First Nations Class Action Settlement Agreement, Canada committed to making all reasonable efforts to develop and introduce new proposed legislation in consultation with First Nations to replace the repealed 2013 Act. Following the repeal in June 2022, Canada enhanced its engagement by working directly with First Nation rights holders, including modern treaty and self-governing First Nations and First Nations organizations, including the Assembly of First Nations and the First Nations Advisory Committee that was created subsequent to the litigation settlement, to advance development of new proposed legislation. S'inscrivant dans la logique de la Déclaration des...
Aligned with the United Nations Declaration on the Rights of Indigenous Peoples, Bill C-61 was developed through engagement that put First Nation voices at the forefront.
Depuis l'été 2022,
Since the summer of 2022, hundreds of engagement sessions have taken place virtually and in person with groups of First Nations or individual First Nations based on partner preferences. 2 consultation drafts of a legislative proposal were also shared with all First Nations communities and posted online to support broad public review. Through ongoing engagement with First Nation rights holders and First Nation organisations, key priorities for new proposed legislation were identified, including the recognition of rights, sustainable funding for drinking water and wastewater services, source water protection, and the need for ongoing engagement on water issues that affect First Nations.
since summer 2022, Canada has also engaged with provinces and territories on the multi-jurisdictional issue of source water protection, a key priority identified by First Nations. Provinces and territories expressed mutual interest in safe and clean water while emphasizing the need for continued respect for provincial and territorial jurisdictions. In addition, an expanded Assembly of First Nations Canada dialogue table was created in late fall 2022 with the purpose of accelerating collaborative work to develop the proposed legislation. The leadership and guidance provided by the co-leads, former National Chief of the Assembly of First Nations, Phil Fontaine, and the newly elected Grand Council Chief of the Anishinaabe Nation, Linda DeBossige, have been instrumental in advancing the legislation before you today. This partnership continues in tandem with the parliamentary process. Bill C-61, the proposed First Nations Clean Water Act, aims to address key priorities raised by First Nations by ensuring that First Nations have reliable access to safe drinking water and effective wastewater services, affirming the inherent right of First Nations to self-government, including jurisdiction over water, source water, drinking water, wastewater, and related infrastructure on, in, and under First Nation lands, ensuring consistency with Section 35 of the Constitution Act 1982 and the United Nations Declaration on the Rights of Indigenous Peoples, including through consultation on federal regulatory and fiscal allocation decisions, establishing principles for decision-making, minimum national standards, and a federal regulatory regime for water services on First Nations lands, and facilitating collaboration between First Nations and federal, provincial, territorial, and municipal governments on transboundary source water protection, including through a First Nations-led water commission. The proposed First Nations Clean Water Act represents a historic opportunity for rights recognition to address harms of the past and to help ensure that they never happen again. With that, we are happy to answer any questions that the committee may have. Thank you.
Thank you very much, Ms. Wilkinson. Next up, we have Mr. Fairburn from the Department of Justice. You have 5 minutes for opening remarks.
Thank you, Mr. Chair. On behalf of the Department of Justice, I'd like to express my appreciation for being able to work on this groundbreaking bill with Indigenous Services Canada. We've worked through the drafting up to the current stage, and we are here to support Indigenous Services Canada and to help answer your questions as well. So thank you, Mr. Chair.
Okay. Thank you very much, Mr. Fairbairn. And I guess with that, we can go into our first round of questioning, the 6-minute round. Well, first, I do want to welcome, we do have a couple of new members on the committee today. I want to welcome Mr. Couric, Ms. Falk, as well as Mr. Scarpaleggia, who I know has put forward a water study of legend at the Environment and Sustainable Development Committee. So I want to welcome all three of you here today. But without further ado, I will pass the floor over to Mr. Melillo for 6 minutes.
Thank you very much, Mr. Chair. Thank you to the officials for being here to talk about this important topic on C61. I just want to start off the top, and whoever wants to answer, please jump in. There's been a lot of discussion about this legislation as being co-developed. That was a phrase that the government has used. And we've also seen in media and in comments beyond that, many First Nations that do not feel adequately consulted in the lead up to this legislation being brought forward. So I'm just wondering if you could speak to the consultation process that was undertaken to get to this point.
Certainly, maybe I can start and then others can fill in the gaps. So there has been consultation or engagement ongoing since 2018 on proposed changes to the then act that was in place. The intensified discussions, though, happened as a result of the water settlement, the litigation settlement, and it included the work I mentioned with the dialogue table with the Assembly of First Nations. Also, there were 2 consultation drafts that were released. They were sent directly to First Nation chiefs and organizations. We also extended the feedback period for the first consultation draft based on the feedback that we received from folks that there had not been enough time. And the drafts were released publicly as well so that there could be increased access for those who would want to comment and provide feedback.
I appreciate that. And when you mention that, is it as simple as reaching out sort of by email or phoning leadership in order to solicit that feedback? Or is it different than that?
I would say there was a mix. There were certainly direct communications out by email and phone calls that were made at various levels through the minister and through officials as well. Also through our regional offices, we have existing relationships with regional organizations and chiefs directly on the ground. We presented at many different fora, gatherings of different sorts, those types of things, and also work with people who were directly impacted, like the First Nations Advisory Committee.
Okay, thank you. And could you speak to how any concerns or opposition to certain aspects of the proposed legislation at that point, how that was dealt with in your department?
So yes, so I think when you look at the development of the bill through its various stages, so through the 2 consultation drafts and ultimately the bill that was introduced, there are a number of areas that were strengthened based on the feedback that was received. We can go into maybe a couple of examples. Maybe I'll ask Mr. Barbosa if he can share a couple of specific examples. Thank you.
Yeah, thanks for the question. It's a pleasure being back. I'd point to like the committee, probably the progressive nature of the consultation draft was substantive. I think to the question is, where did we see kind of the most substantive feedback from rights holders? I would say it's not universal, but I would say it's progressive, and where we saw substantive kind of uptake on changes include, I would say funding was a significant point of conversation with rights holders since 2018. And I would note that the draft bill discussed today has significant provisions related to providing the absolute best nature of funding certainty. I would also say that the work of the First Nations Water Commission was progressively raised, and the language in Bill C61 is progressive as well. As to our fairly significant languages around substantive equality and providing services that are comparable to local municipalities are things that were demonstrated loud and clear from many rights holders and are entrenched in the draft bill being considered in front of this committee.
Thank you both for that. I appreciate that. I want to speak to the water protection zones that are identified in C61, but not defined. And I think that's a clear distinction and an important distinction. It's left largely to future regulation on the part of the minister. I've heard some concern about that and how vague that could be. So I'm curious if there's been any preemptive consultation specifically on what that might look like in terms of a definition for a protection zone.
Thanks for the question. There are, with respect to the protection zone language, I would say, like in summation, maybe going back to the previous question, there were 3 large areas of focus by First Nations. One was around rights. This is a rights-leading bill. The second is around funding. And the third is the interplay of laws and jurisdiction that makes up the fabric of this country. In relation to the protection zone, there's essentially 3 things happening in this legislation. The first is to the question, the identification of what a protection zone is. Sources of water in this country vary greatly. In some cases, like in the Athabasca, they're very large. In other cases, they're much more geographically limited. And so the identification of a protection zone is something that's highly localized. And so identifying what a protection zone is and the alignment of laws is kind of a core part of this proposed legislation. The second feature around the protection zones is largely around the participation of First Nations and respective provinces and territories coming together to join agreements on protecting water. Water flows, jurisdiction is finite and has defined borders. And as Ms. Wilkinson mentioned earlier, there's a regulatory gap on reserve that should be bridged through the creation of essentially local laws, and how those laws align to broader laws in a particular provinces and territory is critical in providing safe water for all Canadians. And so the protection zone really begins with, one, the conceptualization of what is the geospatial kind of footprint of a protection zone, and then moves
Mr.
towards...
Barbosa, I'm afraid I'm going to have to ask you to wrap it up.
Thank you. Apologies.
But with that, we'll go over to our second questioner here, Mr. Batiste, for 6 minutes.
Thank you, and thank you for your opening comments. You know, one of the things you had mentioned in your opening comments that there currently exists no protections for First Nations water and regulations. And this is something that, you know, First Nations have had to deal with across Canada for generations. This is an important piece of legislation. I have 2 questions on this. We've seen many times where industry have been bad actors and not always looked out for the best interests of their neighbors in Indigenous communities. That has led to contamination and poisoning of the water. I know that you're going to hear testimony late. We're going to hear testimony as this, but you know, one of the sites in Nova Scotia, Pictou Landing, for more than 4 decades, had their water poisoned by a lumber mill close by. And I'm wondering 2 things. How is this legislation going to protect First Nations drinking water from pollution, from contamination? And 2, what is the provincial role in this to ensure that they're working collaboratively with the federal government? Because it was the provincial government that allowed the polluting of this community in Nova Scotia for many years. I'm wondering if you could speak a little bit about what this legislation does to protect that, and how can we ensure provincial governments follow suit?
Thank you very much for the question. In terms of the legislation and the source water protection that my colleague did mention earlier, and how water flows, and it's a multi-jurisdictional issue. So it's really about creating pathways as water flows onto reserve land and off of reserve land to ensure that provinces, First Nations, and the federal government are working together. So it's not just Indigenous Services Canada, but it's also other federal ministers coming together and using all those regulatory powers that exist in Canada to work with provinces to coordinate those laws and support First Nations on that safe drinking water. I'd also add that there are regulatory making abilities in the proposed bill itself on First Nation lands. And so with those proposed regulations, they would go through the normal Gazette process where everybody would be included, including provinces and territories. But in addition to that, there are commitments for that ongoing consultation and cooperation with First Nations as the rights holders to protect their drinking water. Thank you.
If no one else wants to add, I'm wondering if Justice could answer. We have, as a federal government, a fiduciary responsibility to Indigenous people. You know, they believe, and I agree, that they have an inherent right to clean drinking water. How can we ensure, through this legislation, that industry or provinces who are acting in bad faith and not upholding their fiduciary responsibilities to First Nations communities, that we have remedies to ensure, legal remedies to have protect this water?
Certainly, sir. One of the features of this bill is, as has been noted, the concept of a protection zone. And so although this bill focuses on First Nation lands, there is the ability of First Nations and provincial governments and the federal government to set out a protection zone which is supposed to be adjacent to First Nation lands, but it can extend out from those First Nation lands and cover source water and other bodies of water that flow into First Nation lands. So through this mechanism of a protection zone, which would be designed and developed in concert with provincial governments, First Nations, and the federal government, we foresee the ability to help protect water beyond First Nation borders.
And I think maybe the other thing I would add is, and I'm sure the committee has heard this in other realms, and we'll hear it in these deliberations as well, is that First Nations expect a full seat at the table for these discussions, and that is, you know, the intent through the bill is for that to take place. We certainly heard that loud and clear through the engagement process, and that's what we believe is here in the bill. Thank you.
I don't think I'll have the time to get this answer, but I'd love for you guys to put it in writing. But I'm looking at Assembly of First Nations website, and they've had 7 annual water symposiums. I'm sure that they had some breakups during the COVID days, but we've had 7 national water symposiums where First Nations were invited to give their feedback. How much are we building this legislation from the direct feedback that we've heard from First Nations during those 7 annual water symposiums?
I don't have the list of the 7 symposia with me, but we've certainly been working very closely with AFN, and we've been present at all those types of fora to have these discussions. As I said, we've been in a funding relationship with AFN since 2018 on engagement, and so we have been very engaged. Sorry, that's a lot of engagement. Anyway, we've been very active in working with those who attend those symposia, because it includes experts as well, right? There are a number of, you know, not just we'll hear, I'm sure, later from some experts on the ground, but really tapping into that expertise has been critical to make sure that the implementation of the Act can be well thought out in advance as well. Thank you.
Thank you very much, Mr. Baptiste. Au prochain, on va aller à...
Mr. Lemire, 6 minutes, please. The floor is yours. Thank you very much, Mr. Chairperson. I thought I'd raise this issue a tad later, but I think it would behoove me to do so right now. Water is the purview of natural resources, which is provincially regulated. In the section on the agreements, 25.1 on other possible agreements, that raises a number of jurisdictional issues and perhaps encroachment on provincial areas of jurisdiction. What about the clause that enables Ottawa to enter into agreements directly with cities and towns? It would be inappropriate that occur in Quebec, but did Quebec give the green light to this project? And will Bill C-61 factor in Quebec's national policy framework, and have you sought their approval in that regard?
Thanks for the question. I think it's important to underscore when we're talking about the creation of a regulatory and legislative environment, we're talking about something called 9124 lands, which is crown lands or reserve lands. In no way does this legislation impinge on provincial jurisdiction. The protection zones are based on mutually agreeing collaborative process between First Nations, the federal government, and provinces and territories. On the question of on feedback from provinces, including that of Quebec, it was clear throughout the process, the consultation process, which was oriented to First Nations, of course, but also provinces and territories, that existing jurisdictions that make up the laws of this country, including that of the Constitution, must be respected. And so this legislation doesn't expunge or impinge on that jurisdiction, but if it's in the zone of bridging, as was mentioned, a significant regulatory gap, but also opening up pathways for joint agreements that don't exist today to talk about how is water as a source of many things, including clean drinking water, how is that being protected across multiple jurisdictions, including that in the province of Quebec?
Merci.
Thank you. I'd now like to talk about the First Nations Water Commission, Section 3829. Now, we worked with a number of commissions and faced issues to do with the mandate that was conferred on those commissions. The devil is in the detail. As a First Nations Water Commission, will it be structured akin to the Nuclear Safety Commission, for example? Will it be modelled on it? We know it's possible to put in place a commission that cannot propose solutions or alternatives. That was the case with the Chalk River nuclear waste site. It's perhaps one of the worst sites where you can actually place nuclear waste because it's at the top of a mountain near the Ottawa Valley and is dangerous for the Anishinaabe First Nations. There are contaminants in the water that affect the quality of neighbouring drinking water. Now, can we ensure that the principle of precaution is upheld when it comes to the flows of water, like Chalk River, for example, Ottawa, Gatineau, where it's only about 200 kilometres away, and they draw their water from the Ottawa River. We've disregarded Indigenous knowledge on the issue of living water, quote unquote, and this issue has been debated, and First Nations prosecuted the Nuclear Safety Commission in this on this issue. Now, will this commission model itself on the Nuclear Safety Commission to some extent?
Thanks for the question. With respect, I'm not super familiar with the commission being the comparable or the comparator. What the legislation proposes is, with respect to the First Nations Water Commission, is I think threefold. One is the aforementioned by my colleague water settlement agreement, committed to create kind of an institution to support First Nations in the administration of many affairs, including, and they're itemized in this bill, and I won't read through them, but including regulatory and capacity supports. The commission in of itself needs to be co-developed and supported through consultation with First Nations, and so the legislation creates the space for that organization, but doesn't and alludes to what it can do. But in essence, what needs to be created is essentially that consultation process to create the commission itself. So Section 39.1 speaks about that process, and then the remaining subsections in 39 speak to these are the potential parameters by which the commission could perform its functions, ranging from operations, maintenance, capacity supports, regulatory development, et cetera. So in passing this legislation, in potentially passing this legislation, what would be created is essentially the venue for that dialogue. Thanks for the question.
J'aimerais vous mettre en garde.
Just a caution about the appearance of conflict of interest with these kinds of commissions. It was the case with the Nuclear Safety Commission. We saw the Minister of Indigenous Affairs and Crown Relations that didn't adopt the principle of precaution for at-risk projects that endangered flora and fauna, and that was the case in the Ottawa River area. The Mandates Commission was such that the ministers offloaded their responsibility and put it on the shoulders of the Commission, and therefore were no longer accountable because they said that it was an arm's length commission, and they told the Indigenous people to take it to court. That was the case with the Nuclear Safety Commission, and I'm afraid that the same thing will occur here. My time's run out. Mr. Chair, if you have enough time, we could have an answer. Thank you, Mr. Lemire. Perhaps there'll be an opportunity to ask the same question in the next round.
We'll go to our fourth questioner here, Ms. Idlout, for 6 minutes.
Thank you, Chair. Thank you for coming to inform us. This bill, Bill C-61, is geared towards First Nations. It's not geared to the Inuit community. Testing. Hello? Testing. Testing. Hello? Testing.
So there was testing occurring, but unfortunately it occurred too late, and so I didn't hear my colleague's remarks.
Thank you.
Thank you for coming to. If I can start by saying this bill act is geared to the First Nations. It's not geared to Métis. It's not geared to the Inuit community. That is what my understanding. It is really will be impacting First Nations governments. How many First Nations governments bodies will be impacted by Bill C-61?
Thank you for the question. So it is geared to, as my colleague described, 9124 lands, so generally speaking, reserve lands. And it's not meant to take the place of the broader Federal Water Act that is developed by Environment and Climate Change Canada. So you're right, it is specific to 9124 lands.
How many lands will be impacted? How many bands will be impacted? That's what I want to know. How many? The numbers, please.
There are 634 First Nations from coast to coast to coast. A proportion of those are self-governing First Nations, which have paramount laws around jurisdiction in some cases, including water. So the rough number, just for frame of reference, is around 580 to 570 First Nations communities. So 634 less the self-governing First Nations.
Thank you. From my understanding, there are over 600 communities that will be impacted. Now, my question is, how many did support this bill, C-61? How many supported this out of this 600 First Nations bands? How many have you heard from? Looking at these, First Nations entities, how many have you consulted with?
So maybe I'll start and my colleague can follow up. So we have engaged with all of them. So all nations were provided with both consultation drafts. And we had lots of outreach to those who were, interested in having discussions, as I mentioned, either alone or in groups through organizations or through direct interaction with the nation itself. Perhaps my colleague can share some details as well.
Yeah, so certainly, thank you for the question. So just to build on my colleague's point, so there was 2 consultation drafts that the draft was shared both publicly online, which is a first for this department for all kind of consideration and feedback. There were, during the consultation, there were daily drop-ins for First Nations. We held direct consultation sessions based on requests from First Nations, coast to coast to coast. They were both virtual and in person, and that helped happen in a concerted way throughout the consultation process. So significant kind of outreach, both direct, indirect, and through written format.
Thank you for that. I want to hear numbers. I want to hear how many First Nations you're consulting with. You talked about engagement. For me, it's not too clear. And now I want you to explain, because the duty to consult is very important. And where First Nations people will be impacted, we need to know how many First Nations bands and also how many First Nations that did you consult with? I want to know the numbers on these.
Quinnipiac for the question. So as my colleagues have outlined, there was a number of ways we did outreach with communities, but we also had over 181 First Nations and First Nations organizations that we met with or had direct correspondence with related to this bill. And since 2018, we've provided over $10 million to a variety of organizations to support engagement in the development of this bill, which included things like the symposiums that your colleague had mentioned. Thank you.
Thank you. My last question, if while I have time left, we were told that the First Nations have concerns, and they were that they had to sign an agreement. And this time, this agreement has non-disclosure agreements. Did you have to get First Nations to sign on to this non-disclosure agreement? Is this true? How many signatures? I mean, what are the numbers?
So I think we may be referring to those who participated in the AFN dialogue table. So we did have non-disclosure agreements with those who were involved in the development of certain documents that required that, but we did not have folks who were being consulted or engaged with on the ground sign those non-disclosure agreements. Because it was public, there was no need for that to happen. Thank you.
Thank you very much, Ms. Idlut. And that concludes the first round of questioning. So first up in the second round, we'll be going to Mr. Melillo for 5 minutes.
Thank you again, Mr. Chair. I'd like to come back to the question of the protection zone that I left on, specifically in Section 21. And I'll ask our officials from Justice for a comment here. So it says that the minister must make regulations defining a protection zone, and goes on further to specify that the minister must consult and cooperate with First Nation governing bodies. Consult and cooperate. So from the Justice perspective, can you define what that would look like in your view?
Yes. One of the key aspects of this bill is to ensure that there is input and continuous feedback from First Nations with respect to a wide variety of things, but including the protection zone. So there is sort of case law which sets out consultation, and cooperation is a newer concept from the UNDA. And we're still working through that as a federal government. But I think from the perspective of justice and ISK, that it would mean that there would be a need to get substantial input from First Nations to ensure that any definition works for their particular needs. These protection zones can exist for any First Nation lands, and so there will be need to work with any First Nation that wants a protection zone. They may need to be tailored to their particular circumstances.
I appreciate that. The reason I ask is because it's one thing to say consult and cooperate, but then of course the minister at the end of the day does have the authority to make those regulations, and we've heard already in terms of just developing this legislation that there are, although the government is saying that they had an extensive consultation process, and I don't dispute that, there are still many First Nations that are saying that they were not adequately consulted, so not a great start. They're saying that in the C61 it's saying that the minister will consult and cooperate, but at the end of the day the minister has that authority to make the protection zone on their own. Is that correct?
The minister would need to go through the whole consultation process before making the protection zone, so it wouldn't be a unilateral process. The minister would need to get that feedback from all for First Nations.
What I'm getting at is the consultation process is a bit fluid. It's not necessarily a strict something that the minister must strictly adhere to, as we've seen just in the simple development of this legislation.
Right. Yeah, I would say that the minister would need to sit down with First Nations. It's not something she could simply do on her own or his own. So there would need to be this buy-in from First Nations, because these protection zones are relevant to particular First Nation lands. The circumstances may vary. So I think making a definition that tried to fit everyone without talking to the impacted First Nations would not be successful. So that's why we've tried to build in this idea about consultation and cooperation.
Absolutely, and don't get me wrong, I think the consultation aspect is a very important aspect of it. I definitely am on board with that. Where I have concern is how extensive that consultation will be, and if the minister theoretically just has the power to check a box and say they sent an email to a First Nation and then can make that decision on what a protection zone is, because again, it says the minister will make that determination in regulation.
I think given the trend these days, there has been a concerted effort to ensure that First Nation voices are heard on a wide variety of topics. So
I'm just running out of time, but I just want to, legally, is there a mechanism that can be embedded within that to ensure that the minister can't unilaterally make that decision on their own?
Well, you could put something in the legislation that potentially went beyond consultation and cooperation. Yes.
Okay. Thank you.
Thank you very much, Mr. Melillo. We're moving on to our second questioner in the second round, Mr. Scarpalegia. You will have 5 minutes. The floor is over to you.
Thank you very much, Mr. Chair. I'm very happy to be here today to discuss this legislation. I'd like to focus a little bit more, and this is in order to understand the issues better and the solutions that are being brought by this bill. I'd like to focus a little more on practical outcome questions. So my understanding is that at the moment, there are no legally enforceable drinking water standards in First Nations communities. That's correct. But clearly the operators in the filtration plants must be adhering to some standards. Which would this vary by community, or would they be adhering to the national, federal, provincial unenforceable water quality standards?
Yeah, thank you for the question. I think certainly there are many fantastic operators that are operating very complex systems in many, if not all, First Nations right now. In terms of the void is largely around enforceability of legislation and the regulatory gap. In terms of standards and practices on water operations, typically First Nations follow Canadian national or Canadian drinking water guidelines or the guidelines in a given provincial jurisdiction, like here in Algonquin territory and in present-day Ontario. There are very strident regulations and standards that govern, in the provincial context, water administration, and there are many First Nations that kind of mirror those standards and regulations in their particular communities. But I think the biggest gap is around one, First Nations kind of voice control over lawmaking, regulatory ability on their lands, but also the lack of enforceability should there be kind of issues related to the administration of water or water systems.
So that's interesting. So the operators have the choice of adhering to the same standards as a local municipality, or they could choose the Canadian drinking water guidelines. I'm trying to understand the difference between this bill and the previous bill that was rescinded. How did the previous bill treat drinking water standards? Did it have a requirement that is maybe not as good as the requirement in this bill for creating and maintaining enforceable standards? Like, what's the main difference between the previous Conservative government's bill and this one, other than the funding issue and recognizing the right to management of First Nations waters and so on, which are extremely important? But on the standards issue, what is the difference between this bill and the previous bill?
Thank you very much for the question. The previous bill from 2013 really focused on enabling a regulation-making framework, so it did not have specific standards in it. So this bill does have specific standards both for drinking water quality, also water quantity, and wastewater services as well. So that is a key difference. In addition to the funding that you mentioned, as well as rights recognition is in this bill and not the previous bill, as well as the Water Commission for those wraparound support services that's in this bill but not the previous bill. And lastly is those cooperation and consultation requirements that weren't in a previous bill either in relation to that regulatory framework.
Thank you. So it's much stricter in terms of creating and maintaining standards. To Mr. Lemire's point, he mentioned that this bill provides the right to engage with municipalities. Did I understand correctly? Is that what Mr. Lemire was saying, that through this bill the federal government can engage with municipalities, including in Quebec?
Yes. That in essence, yes. What this bill does, the concept of protection zones, is to align laws that both are laws both on and off reserve, which requires obviously a dialogue between federal or First Nations, provincial, territorial, municipal governments who administer those laws and systems.
Because I know when it comes to financing infrastructure in cities in Quebec, a city needs to obtain approval. It's called an M30 in Quebec before any federal money can flow to that municipality. But are there any restrictions within Quebec law that prevents the First Nation or the federal government from consulting a local municipality in the way that you've just described?
So,
Sorry, I'm just going to have to ask for a quick answer.
Sorry about that. The time flies. You don't realize it when you're asking the question.
So, sir, are you wondering if there's anything in Quebec law that prevents the federal government from consulting with Quebec municipalities? I don't know Quebec law, I must admit.
But nothing you've heard of?
No, nothing I've heard of.
Thank you, Mr. Chair.
Thank you very much, Mr. Scarpaleggia. Prochain, on a Monsieur.
Next question, we have Mr. Lemire for 2.5 minutes. The floor is yours, sir. Thank you very much, Mr. Chairperson. So I'd like to come back to my question from earlier. Is the Commission's mandate to going to mean, as is the case with the Nuclear Safety Commission, that ministers will no longer be responsible for what happens in the industry, and that Indigenous communities may again be at risk and will have to go to court to seek remedies. Will the Commission have powers, or will a tribunal or court impose penalties? What about conflict of interest concerns as well?
Thank you for the question. So we're certainly envisioning, and the input that we have heard from partners is very much that the Commission would be First Nations led and independent from the federal government. So there would be funding provided, we would be a partner, but it would be First Nations led, First Nations governed. So it's not an ISC commission, it's a First Nations water commission. And the views and the input that we have heard to date is really around that serving as a center of expertise to provide technical guidance and support to communities. But what we've outlined in the proposed legislation is a commitment to cooperate and collaborate with First Nations as the terms of reference get developed for that. So there's no preconceived notions around what, the mandate of that has not been finalized. That will be work that's done once the legislation is passed. It'll be one of the first orders of business in terms of implementing.
Bon, donc on a comme législateur.
So as legislators, we're going to have to trust that, well, in the case of the First Nations historically, we know that trusting has often been disadvantageous to them. Now, the government is going to collect a lot of information, personal information about people. To whom will that information belong? Will it be open source? Will it belong to First Nations, to the federal government, the provincial government? And of course, who does the water belong to? Or are these going to be shared areas of jurisdiction?
Thank you for the question. Maybe just to add some additional pieces, because the Commission does complement other elements of the proposed bill, including the rights recognition and the principles that are laid out in the bill. So there is data sharing and data principles in the bill that would be guiding all decision-making throughout the whole bill, including the co-development of those terms of reference for the Water Commission, as well as any agreements to support the exercise of First Nation rights. So in terms of those First Nation rights, it's really about recognizing First Nation jurisdiction and their leadership, and that their knowledge is theirs.
Merci beaucoup, Monsieur le Maire. And with that, we'll go to Ms. Idlout for 2.5 minutes. The floor is yours.
Thank you, Chair. The Chief Chris Monias of Neskantaga Nation said after Bill C-61 was introduced that he did not get the chance to review it before it was tabled. He said this is colonialism at its finest. How was this bill allowed to proceed without the consultation of one of the main plaintiffs? How was this bill allowed to proceed without the consultation of one of the main plaintiffs on this Bill C-61?
Thank you very much for the question. So as contemplated in the 2021 settlement agreement, there was the creation of a First Nation Advisory Committee that did, if you go through that settlement agreement, it does have diverse First Nations from all over present-day Canada that are represented on that committee. That committee was instrumental in its role that's defined in that settlement agreement to inform that development of the proposed bill that is with you today. So similar to the dialogue table that my colleague mentioned earlier, there was ongoing work with that committee to ensure that it lived up to the settlement agreement. Thank you.
I would like an answer why the Chief, Chris Moniz of Neskantaga Nation, why was he not presented with this bill before it was tabled?
Appreciate the question. It is a bit difficult for us to answer as we are not the chief. So it's ultimately up to First Nations and First Nation leadership to define their role in the development of that process. We take all input that we received very seriously to move forward to strengthen the bill that you see with you today.
Did you give him an opportunity to review this Bill C-61?
Sorry, just a quick answer, if that's possible.
Yes, it was part of all of our outreach to every single First Nation across present-day Canada.
Thank you very much, Ms. Idlout. Next, we'll be moving to Mr. Melillo for 5 minutes.
Thank you, Mr. Chair. I want to come back to the protection zone once again. Then I promise I'll move on to another topic. I just wanted to make sure that I was clear in my earlier questions, and I'll come back to justice again if I can. And with respect, I'm not interested in what should happen or anything like that, but what could happen with the current legislation that's drafted here around the protection zone. I'm wondering if the minister could define what the protection zone would be without the consent of one of the parties, the First Nation or the province or territory. Could that happen as it's currently drafted?
Yeah. It's always important that a minister's discretion is not fettered. If they have a legal ability to make a regulation, for example, that is a key consideration. But what we've tried to do in this bill is say that before making a regulation, it's critically important to consult. So that is a key factor that the minister would have to do before she even got to the regulation making stage. So in this bill, she couldn't skip that.
Understood. Thank you. I appreciate all that, but you did answer the question. The minister could make that definition without the consent. So I appreciate that. Further, last question on the protection zone. Are there any other, and this is to anyone who wants to comment on it, are there other federal acts that achieve or at least aim to achieve what the protection zone would achieve currently in law?
So are there other federal acts that are similar in that they provide a protection zone?
That they would cover what the protection zone is aimed to cover?
I'm not aware of acts. I mean, Canada has several federal statutes that deal with environmental matters on lands throughout Canada, but this protection zone is a fairly unique concept that we've built into this bill.
Okay. Thank you. I appreciate that. On the water quantity standard, changing gears here, I promised I would do that. I think it's important to ensure that obviously the quantity of water meets the needs of the community. I've heard concerns from some First Nations about how those needs are defined, such as leaving out agriculture as an example in the standard. So I'm curious how that list of needs was determined by the department.
Appreciate the question. This was a key area of work with our First Nation partners. As you'll notice from the first draft that was released publicly and is still online, as well as the second draft, and then what was introduced in Parliament, there has been substantial changes to those standard pieces that took direct input from First Nations and applied it to the bill that's with you today.
Okay, and could you speak to how the quantity for current and future needs would be determined?
Appreciate that. Similar to the broader bill, the main guiding principle is about consultation and cooperation with the rights holders. So that determination would be done directly with First Nations, as we do recognize that there are different needs from community to community, whether there be drought, for instance, or other factors at play in different regions across present-day Canada. So it would be developed directly with communities.
Okay, I think it's important to note as well that there are many First Nations that share same source water as non-Indigenous communities as well. So would those standards have any impact in cases of drought or situations that put extra stress on those systems, especially when they're being shared with other jurisdictions?
Appreciate the question. So it does really get into kind of agreement-making abilities that are outlined in the proposed bill. So the proposed bill really allows for agreements with multiple orders of government to be as inclusive as possible for holistic approaches around different watersheds in different areas of present-day Canada. So the idea being very much that different communities would come together to work on what works best in their area.
Thank you. I think I have time for one more question. I'd like to ask about just broadly, the bill uses the term best efforts, I believe, in 8 different sections or subsections of the bill. I've heard, again, many First Nations raising concerns about that language because it's very broad. I think we would hope that the minister is always making their best efforts in everything that they're doing. So why is that language so vague? Why was that language what was settled on?
Thanks for the question. There is multiple references, as you've mentioned. I'd probably point to a couple of them. In terms of funding, it talks about certainly one of the core feedbacks that we heard from partners is funding predictability, and my colleague from Department of Justice talked about the role of ministers and of course parliamentarians that are in this room on appropriations of funds, and so how does that work in modern day Confederacy is important. But those best efforts, particularly in the funding, are buffered by other things that talked about what makes water systems run. What are the costs? What are those true costs? How are those being assessed regularly? How are those being reported? At the back end of the legislation, you'll see reporting annually to parliamentarians as well. So best efforts isn't only about the language, it's about the intent of the subsections of funding and others, and ensuring that goes through the democratic process, but also is done in a transparent way. Thank you.
Thank you very much, Mr. Melillo. And with that, we'll go to Mr. Carr for 5 minutes.
Thanks very much, Mr. Chair. I just had a question in the opening remarks from Ms. Wilkinson, as well as what appears to be language in Section 35, based on what I read in the legislation. It refers to an inclusion of affirming inherent rights under First Nation lands. Can you elaborate a little bit on what that refers to specifically when we talk about under First Nations lands?
You could do
that. Yes. So the idea is that water can be on First Nation lands in the sense of a lake, a river. It can be under it in terms of a reservoir under the lands. So the idea is that First Nations would have jurisdiction over not just the surface water or a lake, a river, but the water within the soil.
Okay, I figured that was the case, but wanted the clarification. Thank you. Can you provide a practical example? And if you have one even specific to my home province of Manitoba, that's even better. But a practical example of an issue that exists on a First Nations community today that has not been resolved because of the absence of legislation that would otherwise be resolved if legislation such as this were in place today. So are you able to provide any type of example that comes to mind of here's a problem in the absence of this legislation, but if this legislation passed, it wouldn't be a problem, and here's why?
Appreciate the question. As many of us get to benefit from today is when we get up in the morning, we wash our faces, we use the washroom, brush our teeth, all these factors about water. So as we know, with a lack of enforceable standards on First Nation lands right now, it is difficult to ensure that we can partner with First Nations to make sure that they have the same equity as everybody else in Canada. So by passing a proposed bill like this, there would be those enforceable standards in place to ensure that.
Okay, thank you. I have maybe a bit more of a technical question, but in the legislation, it refers to First Nations, and in the section that provides definition of terms, First Nations is not in there. I presume that just simply we use the Section 35 definition of First Nations. But where I'm curious is, when we're referring to First Nations in the bill, does that mean First Nations as members of a collective First Nations governing body, or does that mean each individual First Nations person? And the reason I ask is because if there is disagreement amongst First Nations individuals in a First Nation community governed by a First Nation body, who is it that the legislation is referring to in that instance? Is it the governing body or is it the individual as the right? I hope that made sense.
Sure, yes. So the idea is that the focus is on the First Nation governing body, and First Nations may sometimes be used in the sense of the broader collective, the broader band, rather than using the term band. It means First Nations. But I guess the distinction would be the governing body is essentially the council, the government, and the First Nation is the collective of individuals making up the band.
Okay, so for the purposes of the legislation, essentially First Nations would refer to the governing body, the First Nations governing body.
Yes, I guess specifically the governing body, the First Nation governing body would be like similar to the council, okay. And then the First Nation is all of the people in
right.
making up the.
So I have one further question, and we probably won't have time to answer it in depth, but let's imagine hypothetically, we have a First Nations governing body that is supportive of a natural resources project. Let's call it a pipeline. If that pipeline and the approval of it was inconsistent with standards that were set out in this legislation, how might that be rectified?
Thanks for the question. May I just go back to the previous question? There are a couple defining terms on First Nation governing bodies and First Nations lands early in the earlier sections that might provide some further light to your previous point. On the question where there might be conflicting law, including those with resource development, those are itemized in one of the subsections called limitation, which talks about should there be conflicting laws, should a First Nations bring a law into force that may conflict with regulatory or natural resource laws, they're itemized in this bill. The limitations talk about the paramountcy of laws and which laws would prevail. This is standard practice in many pieces of legislation, but I think if the question is about where there is a conflict of laws, that's itemized in this bill as well, if that's your question.
Okay, I'm out of time, so I'll pull you aside after and clarify. Thank you. I knew it would take more than 90 seconds, so thanks.
Thank you very much, Mr. Carr, and that completes our second round of questions here. And I just want to put something out to the committee to see if there's consent on this for the next round to have it be our last round and have 5 minutes for each party to ask questions. Before we need to move into committee business to do a few things that we talked about earlier. So, okay, we'll see in agreement. We'll move ahead with that. First up in the third round will be Mr. Melillo for 5 minutes.
Thank you, Mr. Chair. You're going to have to take tomorrow off. I appreciate the opportunity to ask some more questions. Yeah. All right. Get some order here, Chair. Come on.
He's going to reclaim his time.
I just want to quickly pick up on the best efforts because we ran out of time there. I'm just curious on if those words "best efforts" are removed from the legislation, what sort of impacts it would have. I mean, I guess it obviously depends where it is. I know there's an instance where it mentions the minister should make best efforts to consult. I think that would be a simple change that the minister must begin consultation. I think that's something that should be possible. From your perspective, if that was to be removed, what general impact would that have?
That's a good question.
Thank you.
I think about go back to the funding one because it's the inference I made before. So if it said the minister must do X, Y, and Z, that would require a fiduciary requirement from the government for Parliament to appropriate funds relative to the agreement being provided. So instead of best efforts to do those things and publicize them and substantiate investment behind those studies, if you remove those words, parliamentarians must appropriate funds legislatively to do the aforementioned items.
Okay. I appreciate that. Back to protection zones. Curious about multi-jurisdictional areas. So I'll explain this a little more. I live in Kenora on Lake of the Woods. It's an international body of water. There are many First Nations on the lake as well. An area such as that, I suspect, could become complicated between Ontario, Manitoba, the state of Minnesota, as well as the First Nations affected. So in terms of defining those protection zones, has there been consideration for situations like that where an international government could potentially be involved or have jurisdiction over some of that water in that territory?
Thanks for the question. In terms of what's embedded in the legislation itself, it does not consider international waters, including tributaries that may flow outside of Canada. It's within the confines of Canada's jurisdiction.
I appreciate that. As well, back to the definition of the water protection zone. In my last round, we confirmed that the minister could theoretically make decisions on defining that zone without consent of the First Nation or a relevant province or territory. It does seem problematic to me that is the case. Is there as discussions or any desire on the part of the department to solidify that into a more specific agreement in terms of ensuring that there is consent from each of those three parties before such a zone could be defined?
Thanks for the question. I'm reading the consultation section, which you're referring to, which is section 22.2. We're talking about the minister must consult with First Nation, et cetera, et cetera. Oh, sorry. Go ahead, Rebecca.
Just maybe to add that provision is really in a broader context of the bill. And so in that broader context is rights recognition that requires kind of a coordinated approach with provinces and First Nations. So there is a requirement of kind of agreement between those provinces and First Nations. So it just suggests reading them together.
I understand that broadly, but how is that requirement of consensus captured? Like, how is that defined or solidified? Because again, we're hearing, this is a perfect example. We're hearing that this bill has been co-developed and that there's broad support. However, my colleague from the NDP, as well as myself and others, have brought forward concerns that we've heard to the contrary of that. So how will that be actually defined and actually actioned in the way that it's intended to be? Because you're saying great things. I understand the sentiment, but the legislation seems to be contrary to that.
Appreciate the question and clarification. So agreements are one way to do it, where there would be signatories of the provinces as well as the First Nations that are impacted. But there are other ways too. So it is a coordinated approach, and we do want to leave space for First Nations as the rights holders with their own governance systems to ensure that those agreements are approached in a way that works for every party. But an agreement is an example of that.
Thank you.
Thank you very much, Mr. Melillo. And next up, we have Mr. Scarpleggia for 5 minutes.
En fait, je veux faire merci, monsieur.
Thank you, Mr. Chairperson. I'd just like to tack on to what Mr. Melillo just asked in terms of questions. It's still not clear in my mind. Now, let's say that the federal government and the First Nations agree on the delineation of a protection zone. Even if they don't get the agreement of the province in question, can they nevertheless state what they believe the protection zone should be, even if the province is in disagreement or does not intend to act to protect the part of the zone that belongs to it? Would that be possible? You know, for example, were there a province or a territory that were saying no, well, would that be a kind of a pressure tactic? You can't force the province to protect the protection zone under its jurisdiction. However, here's a map of what the delineation would be for the protection zone to protect the health of the First Nations, and public pressure would force the province to act. Is that one possible solution? That might be possible under this legislation. I don't know if you get what I'm saying here, but...
Absolutely. Definitely appreciate the question. And it is aligned with the rights recognition components. So anything that would be on First Nation lands wouldn't necessarily need agreement of the province. However, we do recognize that water flows, and so those pathways for that coordination are also provided for to help ensure that. But a First Nation could pass a law on their First Nation lands recognizing that water flows, mapping their intake of water and their distribution of water as well. Thank you.
Okay, donc cette carte pourrait inclure.
So that mapping could include protection zones that fall under provincial jurisdiction then?
Yeah, as part of First Nations planning.
Deuxième question, on sait que le nœud du problème, là où...
Just to follow up, we know that the crux of the issue is, and the problem in the past has been when it comes to the management of drinking water in a First Nation, often the issue is a lack of adequate funding to maintain the water systems. There's been underfunding over the years. There was a formula back in the day that wasn't ideal in the sense that it wasn't updated. How can this legislation, how will it ensure that there's adequate funding on the part of the federal government so that the drinking water system is properly maintained so that there's no funding shortfalls?
Thanks for the funding. There has been significant investment in the water space, including in operations, which was recognized by the Parliamentary Budget Officer a few years ago. But in terms of, as it relates to Bill C-61, the funding framework that we had talked about previously outlines a number of things that must be considered as part of that framework, including the operations and the actual costs and the operations and maintenance of systems. So it's considered in this bill under the financing section, as to our many other things.
requirement that they
As
get all
yeah,
this right.
So the funding framework really kind of, in my mind, is one, this doesn't exist today. The consultation around what is the actual cost for a number of things that are itemized in this bill. So creating that funding framework is kind of item one. And then two, the minister's use and public reporting of that framework are also conditions of the proposed bill.
Ça va, Monsieur le Président, je crois que j'ai terminé.
Mr. Chair, I think I've finished. Oh, no, I did have another question. Now, is this bill and the Canadian Water Act, is there any relationship between the two? Do they dovetail with each other, or is there an overlap in some way?
The question. So they are complementary in nature, absolutely. So it is our kind of sister department, Environment and Climate Change Canada, that is responsible for modernization of that Canada Water Act. But ultimately, they both touch water, and they both have kind of agreement-making abilities. This bill before you is really focused on First Nations and First Nations drinking water on First Nation lands, but they are complementary in nature.
And I'll just add as well that we did have officials from Environment and Climate Change Canada who are engaged on the Water Agency and the Water Act as part of the dialogue table that I referred to earlier. Thank you.
Thank you very much.
Merci beaucoup, Monsieur Scarpa.
Thank you, Mr. Scarpellejo. And on that note, we'll turn to Mr. Lemire for 5 minutes. The floor is yours, sir. Well, thank you very much, Mr. Chairperson. I'd like to underscore the exceptional work of water operators in Indigenous communities, and I'd like to see a provision in the legislation to recognise the essential work that they do. We often take for granted the water that we drink. It's an invaluable resource. But just like with police services, if we talked about wastewater and water management as essential under Clause 3, would it ensure that the First Nations would get the service funded fairly and equitably vis-à-vis non-Indigenous run services?
Sorry, just so I understand the question. If the question is about recognition of the important work, I agree with you, that operators do, how do we entrench that recognition in terms of a funding commitment? Is that, just so I understand clearly?
Well, so that drinking water and wastewater treatment can be recognised as essential, and as a result, that there be adequate funding for those services.
Yeah, I think that's a great question. I think some of those provisions are enumerated in the funding commitment section, so I think they're covered, but open to views, absolutely. Thank you.
Now, does the bill respond to all the remarks made on the 19th of April 2024 by the Special Rapporteur of Human Rights on Drinking Water, Mr. Pedro Arrojo Agudo, at the end of his visit in Ottawa on the 19th of April 2024? He was highly critical of Canada when it came to the First Nations. Will this bill respond to the international criticism that we've had to weather back home here in Canada?
Question. There is in the preamble of the bill, there is recognition and acknowledgement of the United Nations work in terms of the Special Rapporteur and his mandate. I will note, however, that the visit did occur after introduction of the bill in Parliament, so we didn't have the benefit of that direct input at that time, but there is reflection in the preamble.
L'article 2. Clause 2 of the bill defines First Nations lands as lands reserved for the First Nations. But what about ancestral rights that are claimed by a First Nation where a land title was confirmed by a court? Why should that distinction be made in a bill?
Yeah, thanks for the question. I would just think for clarity in terms on the technical side, I understand what you're saying, and certainly we've heard that consistently. I would just say the parameters of this bill are clear, and they speak only to what are called Section 9124 lands, which are reserve lands for First Nations. So those are the parameters by which this law would apply.
Now, on the issue of Section 39 on immunity, I'd like to ask you a question of about the general provisions in light of the recent research on the impact of climate change and the way of living of Indigenous communities. What is the corporate responsibility in terms of pollution, the use of dangerous chemicals and other chemicals that may cause harm to individuals and their children? Is there an accountability mechanism set out in the legislation? Will the government will the buck stop with the government, or will Indigenous people be responsible to some extent?
Thank you for the question. I think in terms of this legislation fits in a fabric of laws that exist in current day Canada, and it fills a gap that we've talked about before in terms of a regulatory gap on reserve and recognition of rights. So it's about the alignment of those things. I think you're right. We all have as duties as Canadians to pass on water to future generations that is both clean and safe. I think one previous question was about enforceability. So First Nations could pass laws that create stricter measures and enforceable measures to protect the waters under their purview on and under their lands. That is a very opaque zone right now, and this legislation would knit that up.
Dernière question.
Final question. Would it be possible from an economic development standpoint for First Nations that they can have transactions from nation to nation when it comes to water ownership? Could they export water, for example?
So this bill doesn't contemplate the export of water, and there is federal legislation deals with the bulk transport and export of water. But this bill does not address that.
Merci, Miigwech.
Merci beaucoup, Monsieur Lemire.
Thank you, Mr. Lemire.
Our last questioner for the round and for the day today. We'll be passing the mic over to Ms. Idlout for 5 minutes.
Thank you, Chairperson. I do have a question where regarding source water protection. I do have a concern because we all know that as First Nations, Indigenous people, we were trying to be eradicated before colonialism came. We ran our own systems. We ran our waters. We ran our. And then this was all taken from us. This was, I recognize this, but we need to give these back to the people, and that there needs to be more consultations regarding source water protection. My concern is, so for example, municipalities or provincial governments, like for example Ontario or the Manitoba government, if they don't want to let go of these of their jurisdiction regarding freshwater, how will this bill respect how to bring back, how to give back these jurisdictions to Indigenous communities? This is all part of reconciliation efforts. So.
Also acknowledge that this is a colonial tool in a colonial system, right? And so it will never be perfect in terms of acknowledging what you're raising here, right? It is, and we heard that very loud and clear as well through the consultation and engagement processes. And, the minister certainly has talked about it at length as well around this legacy and how it is embodied within a colonial system. That's part of why we worked very hard to break some of the traditional practices in government around the sharing of drafts, for example. That had not been done before, certainly in our department, in terms of sharing drafts online, sharing those in advance of a bill coming to Parliament, that those consultation drafts would be shared. And certainly that consultation and engagement will be ongoing. We've talked a little bit about some of the clauses where the minister must consult, must engage, must cooperate with nations in order to move this work forward. So I hope that helps to answer the question.
I do want to believe what you are saying. I want to believe, but however, I've been told that Bill C-61 was tabled. You were invited to by Chief Monias. They did tell you, they did request to the federal government that they wanted you to come to the Neskantiga community, and then for you to present to the community on this proposed legislation. You did not go to the community to consult with the people. We all know that Neskanka Nation has had to boil water for the last 28 years. And they invited you to their community. You did not go to their community. I do want to believe you, but if you haven't responded to Chief Monias, how can we believe you that you will be delivering these because we need to bring back source water protection to Indigenous jurisdictions.
To Neskantaga and not gone. I have not been invited and not gone. Our officials and the minister meet regularly with Chief Munias, and certainly we're we continue to be open to having discussions with any chief and any expert, any individual who wants to continue to have these conversations. Our team does meet on a very regular basis with Niskandiga around the water advisory, but also the connected issues within the community, because it is, it is a holistic approach that is needed there, and that the department has responded to, whether it's through the Trust the Taps and those types of initiatives with the community. But I'm not aware of an invitation that has not been responded to. Certainly, we'll go back and check with our officials and make sure that if there is any outstanding correspondence or invitations, that we respond immediately. Thank you.
Third and final panel today. I want to thank all of our witnesses for being here today and for their testimony as we start the study of Bill C-61. And that will conclude this portion of the meeting. So we are going to go from public to in camera for the next part of the meeting, so we will briefly suspend.